Good afternoon, everyone. Welcome to our monthly Dallas Volunteer Attorney Program, CLE. My name is Kristen Salas. I am one of the mentors here at DVAP, as we affectionately call ourselves. Today, we will be learning about service of process and attorney ad litems for publication cases. For those of you that are not familiar with DVAP, we are a joint project of Legal Aid of Northwest Texas and the Dallas Bar Association, and our primary mission is to match low-income Dallas residents with private attorneys that will work their civil case from start to finish. In every case involving litigation, obviously we have got to serve the respondent or the defendant at whatever the case is. So we are going to learn about tricks and tips on how to get that done effectively. And if your case has to be done through publication, we're going to learn about what the attorney ad litem needs to do in those particular cases. So today we have got two speakers. We have first speaking Dawn Fowler, who is board certified in family law. She's a sole practitioner in far north Dallas. She specializes, of course, in family law matters, has served as attorney ad litem, amicus attorney, and attorney ad litem in publication cases. She's the former chair of the Dallas Bar Association's family law section and the solo and small firm section. She's currently serving on the Dallas Bar Association's Publications Committee and the Unauthorized Practice of Law Committee. She has also received the Ken Fuller Pro Bono Service Award and the Chris Reed Brown Scholarship for her pro bono work. Also speaking is Jim Cobb. He's a solo practitioner concentrating in family law matters. He is pretty much our go-to guy for publication ad litem work. He's also served as guardian ad litem, amicus attorneys, and of course, attorney ad litems in publication cases. Both have Jim and Dawn have been volunteers, mentors, and CLE presenters for us for many years. So and if you do have questions, do please put them in the Q&A at the bottom, and if there's time, we will get to those at the end of the presentation. So without further ado, I will turn it over to Dawn.
Good afternoon, everybody. Kindred spirits. I love talking to this group. So thank you so very much for giving back to the community, especially the legal community, making us look good because we need it. For those of you who are new attorneys or new to DVAP, I think you're going to find that you get back more by giving. You also meet a lot of great people. I don't know if I would have met Jim otherwise, probably through the family law bar, but nonetheless, we have both been involved with DVAP for a very long time. And it's been great to know him and have him as a resource. And believe it or not, I have gained a lot of referrals through DVAP cases. So it's not only good for your business and good for your soul, but and good for the community. Today, Jim and I are going to be talking about service and ad litems. These aren't exciting subjects at all, but they are critical. You can have the best pleadings in the world, the best court order that covers every T and I that you could possibly need. But if you don't have valid service, you don't have anything. You have a void order because we're talking about personal jurisdiction. And unfortunately, it's not hard to find cases where things have not been done properly. I was talking to one of our family court judges, and she said, Dawn, you wouldn't believe how many times cases are not proved up properly. There's not proper service. Going through the prove up the jurisdictional prongs are not even discussed. So it's very important to learn the how-tos to make sure that you're not in that position. And just this last month, there was a case reported where the officer's return wasn't filled out at all. I mean, all they did was they attached proof of service by a DHL courier, but they didn't fill in anything. And so it wasn't good. And the case is extremely important because it points out and reminds us that actual notice is not sufficient. Person can know that a lawsuit's pending, they can have a copy of it. They can know the contents of it. They can have had discussions about it. But if that service has not been done properly, jurisdiction has not been conveyed and a valid court order cannot be entered. I'm the attorney ad litem on a publication case right now in probate court. And I looked at the officer's return and it says that the respondent was served in person, gives the address, everything is filled out properly. However, it was served in New York City. And I thought, I don't really think a private processor was paid to go to New York City and to hand this to someone. And guess what? When I called him, he said, well, no, I had the clerk send it by certified mail. And so I said, well, your officer's return doesn't reflect that, number one. And do you have a green card? No, ma'am, I don't. So they're going to be starting over on that one. And that's not necessarily something you might think would happen, but when you just sometimes have to use your common sense and check on it. Because that could have gone through and then down the road, it could have been challenged. And my favorite case is Texas Supreme Court case in 2020. And this gives me shivers because I could be this person who looked at this return and thought it was perfectly okay. Because what they did when they filled in the officer's return and said where it was served, they put it was served on Heathers Hill Drive, when actually it should have been served at Heather Hills Drive. So the S was behind the wrong word in the address. And the Texas Supreme Court said, no good. Sorry, no banana on that one. So as I said, it's critical to check to make sure that everything is done right. There's been lots of changes in recent years on how we do things, especially with the e-filing system and the public information internet website also, which is administered by the OCA. But one thing is very, very consistent, and it probably always will be, and that is the lack of consistency and conformity between our courts and what they want to see from you. And sometimes it's going to be a bit of trial and error and persistence and patience on your part. Another consistency is the rules themselves. They've been amended to kind of update things to 2025, but they still haven't changed that much. But always remember to read them. I almost always print out what I'm doing and make a checklist. And I always, when I'm preparing for the speech, and Jim has said the same thing, we find something that we've forgotten or that we didn't even know was there. So you're always going to be learning something. And nothing takes the place of reading those rules. Texas Rules of Civil Procedure, the Texas Family Code has its own set of requirements for service, the statutes, and we have the Dallas County local rules, we have the Dallas County local family court rules, and every court has a website on which they have their policies and procedures, as well as a court coordinator who can help you if you have questions. So be sure to take advantage of those resources, but also be sure that you read the rules and are familiar with them. You have two papers provided to you today. One is on publication. One is on, one is on publication ad litem. One is on service. They are meant to be very practical, a how-to. The one on service that I prepared is literally how do you do this if you have a constable? How do you do this if you're doing this under 106? How do you do this if you're doing publication? And also remember, we're just talking about family law cases. Civil courts have their own rules, probate courts have their rules. Collin County, if you ever practice up there, has very specific forms that have to be filled out before you can do a prove up. And I actually included those in the paper because they serve as an excellent checklist to make sure that you've done everything you need to do. So again, why is service important? It all boils down to jurisdiction. And unfortunately, there is no presumption in favor of a valid issuance, service, or return of citation. So if it's not done right, again, jurisdiction doesn't attach, and the court cannot have the authority to make any orders that are valid. Initial questions you want to ask is, will the respondent sign a waiver? That makes it easy, assuming the waiver is done properly. If not, do you know where the respondent is located? And what do you need? And who can serve what is needed? Is the respondent in the military? There's certain extra steps that you'll have to go to if they are. You may have to find out how to get them served on their base. Is the respondent in jail? Makes it really easy to find them, but you have to go through some additional steps in making sure that they are properly served. Will the hearing be in person? And does the Attorney General need to be notified? Basically, the Attorney General is also going to have to be notified when you're talking about termination, establishment, modification of a child support obligation that has been assigned to a 4D agency. In the paper, I give you a link to their website, which includes the notice form that you fill out and submit to them. So they've actually made it pretty easy. Let's talk about waivers. And I'm just pointing out the high points of sometimes what people miss. But a waiver has to acknowledge receipt of the pleading and expressly waive service. And the pleading needs to be specifically named. So if it's a first amended original petition for divorce, that all needs to be written out. It needs to include the respondent's mailing address, and I go ahead and include their email address and their phone number. Email address so that you can e-serve them in the future. The most important one that people still miss, even after eons, is that it has to be served by the respondent after the lawsuit is filed. And what I do, I still do it to this day. I did it when I was a baby lawyer, but I still do it now, is I never file those, I never prepare those waivers until after I get the petition back. That way I know that it has been filed. I have the case number to fill out on the top, and there's no potential there for it to be signed prematurely. It has to be verified by someone other than the attorney or their staff. And obviously it has to be filed in the case. You cannot use an unsworn declaration. I know we're using those more and more and more in other cases, unless the respondent is incarcerated. In that case, you are allowed to use it, but in normal waiver, you're not. And a digitized signature is not permitted. There is a House bill that is currently pending in the legislature that would permit a digitized signature, so you might be on the lookout for that. Some other practice tips besides waiting until you get the original petition back is some people do waivers that only waive service. Some do waivers that waive both service and notice. If you have a waiver of only service, and an agreement is not reached, you're going to have to give the respondent notice of all hearings in accordance with the rules of civil procedure. If the waiver includes both service and notice of all future proceedings and amendments to those to your pleadings, be sure to check with the court to make sure that the respondent hasn't withdrawn the waiver or filed an answer. That does happen. And a lot of times you're not going to be notified. So be sure to check the court register to make sure that hasn't happened. And again, if it does happen and you can't reach an agreement with the respondent, you're going to have to give them notice. I have been noticing on some attorney listservs that across the state that more and more counties and courts are requiring notice even if they have a waiver of everything. So again, be sure to check with your court coordinator to make sure that the judge is not going to require a notice of your final prove-up be given before you can take a default judgment. On personal service, most of your personal service in a DBAP case is going to be done by a constable. Major tip I have is just follow up and make sure that the constable files the officer's return with the court or sends it to you to e-file. every office has a little bit different procedure, so you need to check with them to make sure as to what you're going to need to do. You also need, as I mentioned earlier, check that officer's return to make sure that it has been correctly completed. Make yourself a little checklist. When did they receive it? What time did they receive it? The date they received it? Who were they supposed to serve? Where was it supposed to serve? And that the name of the respondent is accurately reflected on the return. Remember that that has to be on file for 10 full days before you can take a default, even if the answer date and the waiting period has passed, and you don't count the date that you file, and you don't count the 10th day. So really, it's a total of 11 days total. Certified mail, sometimes people use this. I don't, and I can't imagine using it actually because most of the time people don't get it back. Then you're going to have to start all over and do another method of service. But if you do, remember it has to be done by the clerk of the court or a private process server. It can't be done by you. It can't be done by the petitioner. And you must have a green card that is legibly signed by the respondent. And I think Jim and I were talking about this. Jim, do you want to make a comment on that?
Sure. I don't see very often certified mail go out because that's just a problem for the judges because they want to make sure that that signature is legible. And if it's not legible, and sometimes we can't even read the judge's signature, but if it's not legible, the judge is going to say, hey, this is not proper service. Sometimes she'll show the card to the petitioner to see if they can identify it. So I would just, if I were you, I would avoid the certified mail.
Thank you. Personal service either out of the county or out of the county or out of state. I would suggest you're going to get the citation issued by the clerk here. They'll send it to you. And then you need to call the clerk or the process server and find out, where are they, especially if it's the sheriff, where are they? Will they waive their fee because it's a pro bono case? Who are they going to return it to? Are they going to send it to the court or are they going to send it back to you? See if they're familiar with doing this because it does have to be verified before a notary public to be valid. A lot of times they don't know that. And again, just make sure that it is completely and thoroughly signed. Another country, call DBAP, get a mentor. It's extremely complicated. I'm not going to say anything more about that. Just find somebody who can help you on it. And there's several people in town who are very proficient at that. Private process, which is misspelled, sorry about that. There is a list of certified private process servers at the Judicial Branch Certification Commission website. Used to just be the Supreme Court, but you had to change it. If they're listed on there, you do not need an affidavit or a specific order authorizing them to serve the papers. However, if you have a TRO or a notice of hearing, it must contain a paragraph authorizing private process. And I have a copy in the paper, and I also have a copy for the prior slide of the letter that you can send to the sheriff that kind of includes everything that I mentioned. If the private process server is not listed on the judicial branch list, then you are going to have an affidavit and you're going to have a court order specifically authorizing that individual to serve the papers. We're going to shift gears to substituted service under 106. Rule 106 is used when the respondent is evading service. They're there, they're just hiding. You're going to need a motion, an affidavit, and a court order. And big thing with the judges, sworn facts about where the respondent can probably be located and sworn facts that service has been unsuccessfully attempted at that location at various dates and times. And on that, if you know the respondent works in the office from 9 to 3, but you're sending the the person out to serve at 4 o'clock every day to their workplace. That's not going to work. If you know they're home, after a certain hour, but you try to serve during other hours, that's not going to cut it either. So make sure that you have those attempts filled out and that they're pretty thorough. 106 basically is usually leaving the citation with anybody older than 16 at a specific location, but it can be any other matter, including social media, email, or other technology. And Jim is going to go into that further, so I'm going to let him cover that better. Again, sworn facts, believing why you believe this is going to actually be received by the respondent. And again, it does have to be done by an authorized person. It can't be the attorney, it can't be the petitioner, and the officer's return must mirror the exact service method. So if the order of authorization says you need to, scotch tape it to the second window to the left from the front door, that's exactly what that officer's return needs to reflect. Even though it sounds silly, it has to be exact. The best return I've ever seen was on a case. I'm just going to kind of highlight what it was. But the person, said they were authorized to serve citation. They include their process server identification number, which is required, and everything else that is required by the statute. But they said, that they attempted to serve. They gave the exact name of the person and where they tried to serve them. They say that's a place where the person can usually be found, and they attempted at, and they go through every date, every time, and what happened. So, for instance, Monday, no answer. Friday, couldn't go because it was raining too hard. That was kind of funny. Saturday, no answer, but the car was parked out front, gives the license number, model, make. Uh, Heard people talking inside, but nobody would come to the door. Tuesday, somebody came to the door, but they wouldn't talk to me. Wednesday, placed a phone call to the residents. Person answered and hung up. Wednesday, talked to a neighbor. The neighbor says, yes, Mary Jones does live there. And then it goes further to say that they checked the county tax assessor records, and the current owner of the real estate it's Mary Jones, and that the car that was parked in the driveway, it belongs to Mary Jones. And then further, that they believe the most effective way of giving proper notice is affixing the citation to the front door of that residence. And that went through, and that was a good one. Substituted service through role 109A. I don't see this used very much. I think the reason for it is because there's a 2-year, it's kind of like publication. There's a 2-year time period during which a motion for new trial can be filed. So everything is extended and it's a little bit extra work, but it is available there where you don't know where the respondent is located. But you think there is a method by which they will receive notice of the proceeding better than publication. And let's face it, there's very few people that ever actually see that publication. You are going to have an attorney ad litem unless there are no children and no appreciable property. And again, you may have to have an attorney ad litem anyway if the judge has that particular policy for their court. As I said, the motion for new trial for 2 years, so longer time period than 30 days. And you have to have a statement of evidence presented at the time of the prove-in. Publication is kind of the last resort, but it's the one we probably see more frequently than in DVAP cases because people have been separated forever. They haven't kept up with them. They don't know anybody that knows them still, and they say they can't find them and don't have any ability to. You do have to have an affidavit showing diligent search for the person. That has to be signed by a party or the attorney, not someone else. You don't need a motion or an order. I see those done all the time. It's just extra work. They're not needed. There is a request form that is filed with the district clerk's office, and there's a copy of that in your paperwork. It is published in the Daily Commercial Record in Dallas, and it's also put on the OCA internet website. So you're going to have two returns. The clerk handles the OCA part. When you file it and request the publication, the returns, the two returns, you're going to have to either, one of them is going to be filed by you, more likely than not. The OCA is going to generate and file their own. And again, you have to have an attorney ad litem, a statement of evidence, and you have the 2-year time period for a motion for new trial. Posting, exactly the same rules, but you cannot use it when there are children involved. On a default, again, I can't hammer this in enough. Check the officer's return, make sure it's completely done and correct. It must be on file for 10 full days. And there's a bunch of other things you're going to have to file. Certificate of last known address, a military status affidavit. If you did substituted service, publication or posting, the attorney ad litem is going to be an essential part of your case. The court may want the attorney to file a written report. Again, that's case by case. And the role of the attorney ad litem may vary by court. So be sure to make connection with your attorney ad litem and make sure everything is done. And again, you're going to have a statement of evidence. Coordinate with the attorney ad litem in setting the hearing. If almost everybody is requiring, whether it's by Zoom or not, to have some type of notice for hearing filed with the court, specifying exactly how the hearing is going to take place. I hope your next service looks like this one, and I hope it's near a beach. I'm going to turn it over to Jim.
Thanks, Don. One thing I want to point out to everybody is that there's a very good paper that was written by Associate Judge Scott Beecham. He wrote it back in August for the family law, advanced family law section for their seminar. And he wrote it back in August of 2023. It's entitled Service and Default Judgments. It's about 26 pages long. So if you don't have access to that, you can email me and we'll email it back to you. But it's kind of like the Bible on service. And I think if anybody that knows Judge Beecham is that he knows the law backwards and forwards. So if anybody wants a copy of that, you can send that request to me and I'll send it to you. It's very enlightening and it's very scary. And you're probably thinking, once you've read it, you've probably committed malpractice, which we all have done that at some point. But let me know if you need that report. One of my jobs today is to talk about publication. That's an extensive talk. So I'm going to talk about being an amicus first on termination and adoptions. A lot of times I'm appointed an amicus to bless a termination or to bless an adoption. Sometimes people get into custody disputes or modification disputes, and they spend a lot of money on their attorneys, and they're at mediation, and for some reason termination comes up, and to save time, effort, and headaches, somebody agrees to terminate, and they write up a Rule 11 or an MSA, and then they try to prove it up in front of the judge, and that automatically sends off a little wavelength to the judge saying, well, I need an amicus on this to make sure that the termination is in the child's best interest. What y'all need to know is that when a lot of times when we get appointed to bless those things, for some reason the attorneys use the term attorney ad litem, guardian ad litem. Very rarely do they use amicus, but I think on those type cases, on private cases, amicus is really the correct term to use for somebody to bless a termination, either because there's an adoption or just an agreed termination. The court doesn't expect you to rubber stamp the termination. you really do have to use due diligence to figure out if this is in the child's best interest. And there are times that I have not recommended termination, which really upsets the parties because they paid me a fee, they paid their attorneys a fee, they have this agreement. So why can't it go through that way? Well, it's not up to them. It's really up to the amicus and the judge. And anytime I don't bless a termination, I tell the parties, hey, I'm not the judge. You have a right to have the judge hear the case. And a lot of times we have a conference with the judge, and the judge says, well, I'm going to follow what the amicus says. Or a lot of times the judge will say, well, let's just set it for hearing and we'll take some testimony. And after the testimony, the judge agrees with me. But realistically, sometimes the judge doesn't agree with me. And the judge, grants the termination. Also, I get appointed as an amicus to bless step-parent termination and adoptions. The main things you need to know is I see a lot of petitions that come through where the petitioner's attorney is asking for waiving the amicus, waiving the social study, waiving the criminal history check. And most of the time, the Dallas County judges always want a home study if there's an adoption. They'll either appoint a private person to do that if you have a private person that you want, or they'll appoint Family Court Services, which does it on a sliding fee. Very rarely have I seen a judge waive the adoption home study. Sometimes they'll even ask for a waiver of the criminal history on the person adopted. I've never seen that waived either. So technically, when I'm the amicus, I look for the criminal history report on the person adopting. I look for the adoption home study. I do an interview by Zoom with the parents. Usually I wait for the home study to be back before I do that interview, because that home study gives me a lot of information on the parents and the child that saves me a lot of time in the interview. But they're those are pretty cut and dried, and I'm not saying you're going to get appointed on those, but basically as the amicus, you're doing what's in the child's best interest, and you're really focusing on the termination and not so much the adoption. There's a few courts that once the termination is done, they'll also want an amicus on the adoption, even though I don't think the family code requires that. That's up to the judge in that court. So sometimes we do the adoption or the termination first, then they come back and they do the adoption, and so I'm serving twice. Now, I keep my fee reasonable under those circumstances because my main focus was on the termination. So if I am the adoption amicus, I usually discount my fee for the second go round. But the main focus I want to present today is how do you deal with a publication ad litem, and if you're a DVAP attorney and you need a publication ad litem, what do you expect from that attorney? Because Don and I practiced a long time and the judges know us and they know us pretty well. If we're doing a prove up as the, say, a publication attorney, now I don't do probate cases, but say in family court, and we're the publication attorney in family court, and it starts going south because maybe there's a court of continuous jurisdiction, maybe the person that is asking for custody of the children doesn't even have possession of the children. They're in another country. So the judge is going, to a certain extent, you can already read on the judge's face, what are we doing this for? And then you're thinking, why is she looking at me? And so even though we're not the petitioner's attorney, because Don and I have been around a while, we have to make sure all the T's are crossed and the I's are dotted. So if you take a case through DVAP, and I think most cases you'll be representing maybe a mom, and let's assume we've got children and a mom, and when you file the case, you need to make sure there's not a court of continuing jurisdiction. So check with your client. A lot of clients don't understand what a court of continuing jurisdiction is. So you'll have to say, are there any child support orders, any medical support orders? Has the attorney general been involved in the case? And a lot of times you'll get yes, and yet you look at the pleadings and it says there's no court. So you got to make sure that you're in the right court. Also, like I said earlier, you need to make sure the petitioner has the children and they're not in another state or another country, and that person is asking for custody of those children, because that's not going to work either with the court. But once you cross that bridge, the next bridge is to make sure they've named the right respondent. A lot of times we have alleged fathers versus I'm going to call it a legal father. So the DVAP attorney would need to ask the mom, is this respondent dad on the birth certificate? Were you married to him? Is there anybody else could be the father? Because we want to make sure that the right man is named as the alleged father or the legal father of the child. And that's something that is a big problem with the courts right now, because people are getting in front of the judges, and the attorney hasn't asked them any questions ahead of time, so they don't know what to expect as far as the pre-vote questions, and they don't answer the questions right. So then the case has to be reset, see if we have the right father as the respondent. If there is an alleged father who is the birth father, he still is required to be served by public somehow, either by publication or personally, or sign a waiver. If the mother of the child has a husband and the husband's on the birth certificate, but he's not the father of the child, you also have to bring the husband into the suit, because he is the presumed father. So you may have to have a citation on a presumed father and an alleged father in this case to satisfy the court and to satisfy, that you get a good judgment. Once the case is filed, assuming a waiver doesn't get signed, and assuming you can't get personal service on your respondent, then you've basically got two options. In my opinion, you either have to get alternative service or publicational service. When I say alternative service, I'm speaking about what Don has already talked about under Rule 106, which is where maybe you've attempted service on the respondent and the private process server went out there and he can't be found. So the private process server has to do up an affidavit detailing what days he went out there, what times he went out there, he knocked on the door on such and such a time and there was no answer. And then that affidavit gets attached to a motion, and that motion and affidavit get presented to the judge with an order authorizing alternative service, is what I call it, where they said, okay, you can go back out there and try to get someone over the age of 16 served, or you do have permission to tack it maybe on the front door. You just need to be careful. That I got caught one time because I said tack it on the door, and the judge said, Mr. Cobb, do you mean the front door, the back door, the garage door? So you have to be specific on that court order as to where you want the service to be. That 106 also provides now for the social media service. I've done several of those where I'm the publication ad litem on social media service. What is required with the affidavit that's required on that is one done that I've seen by the attorney, where they've got copies of text messages from the respondent. They've got copies of Facebook, of the Facebook pages where the mother's been communicating with the respondent, and all those copies are attached to the affidavit saying that they're requesting service by Facebook, email, texting. So the judge will look at those that affidavit along with all those text messages, the Facebook messages, to determine if that's a good way to serve the respondent. If it is, then the judge will sign an order authorizing service by Facebook at this page. It'll put the description of the page, email at this email address. So that all goes in the order. And then the private process server then gets that order and serves the respondent at either the email or the Facebook, and then he'll issue a return back to the court with what he his copies of everything he sent in so we can look to make sure, and I have to check to make sure he followed the court order and that he actually sent it to the right email address, he sent it to the right phone number, he sent it to the right Facebook page. So that's something that your publication, I call it a publication ad litem because they'll appoint an attorney ad litem, even if they're serviced by social media. And they'll stamp that on there that if there's no response to social media by an answer being filed, we want an attorney ad litem appointed for the respondent. So they're doing that now. If you don't get that type of court order, then you're down to the publication, which Don is, and this needs to be stressed, you don't need a motion and a court order to authorize publication. You can do it on your own, but before you do a publication, you need to file an affidavit with the court saying that the respondent's name is this, that the respondent is, his address is unknown. We've exercised due diligence to try to find him. That affidavit that I just cited is not good enough nowadays. It used to be good in the old days, but nowadays you have to, some of the courts have said that's not a good affidavit. You need to put specifics in there, like a date of birth, the last place you saw the respondent, what his phone number is, what his email address is, what the names of his relatives are, when did you last have contact with him, either by phone or an email, where do you think he is? And now those affidavits are like 2 or 3 pages long because all that information should be put in there. But once that affidavit is filed, then you can do publication without a court order, because that's what the county needs, is that affidavit to start the process of publication. As Dawn said, there's an in-house form now that's online that, and I don't e-file these anymore, but because I'm not on that side of the fence, but there's a publication request form that you have to fill out requesting publication on your respondent. And what you need to be aware of is that there's 2 types of publications now. A newspaper publication, which is run by the Daily Commercial Record, and an internet publication that's run by that's posted on the Office of Court Administration down in Austin. We call that the OCA publication. And the OCA publication has to be run on all family law cases, no exceptions. The newspaper publication only has to be run on cases where you've actually paid the court cost by the client or the private attorney. So if you're a DVAP attorney and the mother petitioner has an affidavit of inability to pay, then you don't need the newspaper publication. All you need is the OCA publication. So keep that in mind, because I know sometimes there's still a lot of attorneys that have never heard of the OCA publication. So make sure you do the OCA publication for sure. The bad thing about the form that's online is that there's two lines for publication. One is, I think it just says publication, but one does say OCA. And you have to check both boxes. And the OCA publication has to be run for at least 28 days. The newspaper publication only has to be run one time. A lot of attorneys, and I know this is getting confusing, but a lot of attorneys flip over to the Texas Rules of Civil Procedure and look at publication, and it says it has to be run 4 times. But in family law cases, it only has to be run 1 time, and which is good, because I think the Daily Commercial Record charges $145 a pop. And if you run it 4 times, that's a lot of money. It's 4 times $145. And some attorneys have done that by mistake, and I don't have the heart to tell them. They just overcharge their client about $500. But the newspaper publication has to be run 1 time, OCA at least 28 days. And that's something, as the publication attorney, I have to look at to make sure it's run correctly. And most judges don't look at those, but there are a few judges, like Judge Diaz in the 330th. She looks at everything. And she has caught me recently because the publication was only run 21 days because she counted it up. And it was supposed to be 28 days. And she gave me this funny grin, like, I'm not going to use you anymore, but she has continued to appoint me after that. But yeah, now for sure, I check that to make sure it's around 28 days. It comes out of Austin, but the district clerk does it correctly, but I mean, without any problem. And it gets filed in your case. When the newspaper publication comes back, it gets filed in there, but that's one of the jobs. And that's really the petitioner attorney's job too, to look at those, to make sure they were done correctly, because as Don said, that you have to have the right name on the petition. It has to be served for 28 days on the OCA, and it'll have the dates on there. On the OCA, they'll go from the last date being the date of service. So if the OCA ran from November the 15th to December the 15th, the courts are treating December the 15th as the date of service, which means then you have to count 20 days from December the 15th to the following Monday before you can default the person. And as Don has already said, if you're doing 2 returns, they both have to be on file for at least 10 days. But you need to be aware too that the Texas Rules of Civil Procedure have a different rule. Their default date is 42 days, but family court cases are 20 days. So I don't want y'all to get tripped up on differences between the Court of Appeal or the Texas Rules of Civil Procedure and the family law rules, because there is a section in the Texas Rules of Civil Procedure that if there's something in the family code that overrides the Texas Rules of Civil Procedure, the family code is the boss. So I know I get a lot of calls saying, how many times do we have to run this publication? But it's very confusing. So just hang in there. One thing you need to be aware of is that after you do the publication, you can go ahead and send an order into the court saying, here's an order for appointing a publication attorney. I know DVAP likes to have volunteer attorneys be publication attorneys too. So if DVAP has a publication attorney that will come out of DVAP, go ahead and get that name from DVAP to put that attorney's name in there, and put in there that he's doing it pro bono through DVAP, so the judge will approve it, because the judges, they know the publication attorneys that do their jobs, and they know the publication attorneys that don't. So if they see a name that they don't know, they're not going to approve it. But if you put in there, it's a DVAP appointment, they will approve that. And I had one that came through the other day that I had to get off of because they're going to use a DVAP attorney, which is great. But once that publication is done, you get your publication attorney appointed. Just be aware that if you're the petitioner's attorney, the county doesn't notify that publication attorney that he's been appointed. And I wouldn't count on the e-filing system at this time be your notification. You need to get that attorney's email, send him an email saying you've been appointed as the attorney on this publication. Here's a copy. You need to send that attorney a copy of the petition. You need to send that attorney a copy of the affidavit, and you need to send that attorney a copy of maybe your client's phone number and email address, because technically, once he starts looking at that affidavit, he's going to have some questions. And when I see that affidavit, I have questions. So I have to call up that petitioner and say, give me the date of the respondent's birthday, or tell me where you think he is, or give me the names of his relatives and their phone numbers, or give me his email address. And they know all this, but they just weren't asked the right questions by the petitioner's attorney when they did the affidavit. So it's not like they don't have any information. But realistically, that petitioner, may not want to find the person. So if I ask a petition, if I was the petitioner's attorney, I said, do you know where your husband is? And they said, no. Well, do you know how to find him? They'd probably say no. But you need to go, the publication ad item is going to go further than that. They're really going to nickel and dime her, or they should nickel and dime her to ask her a question about him, as far as maybe where he's born. Where did he last live? And when we get all that information as the publication attorney, we have to act on that information. So I'll run searches on different websites once I get that information from the petitioner, being the mom. The websites I usually use are VineLink, Facebook, the immigration website, publicdata.com, Google, dallascounty.org, researchtexascourts.gov, accurate.com, Family Tree Now. Now, realistically, if you don't do a lot of publications, it's not, some of these websites cost money, is all I'm saying. So if you don't do a lot of publications, you may not have access to these websites like Accurate or publicdata.com. But the best website that I can tell you about is probably Family Tree Now. You probably ought to look yourself up on Family Tree Now to see what information they have about you as an attorney, because it is kind of scary that they know all that stuff about you on the internet. But I use these websites to try to get some information, or at least try to verify information about the respondent. Then I act on that information, send out letters, send out emails, see if I can find the person on Facebook. I message them on Facebook, and then at some point, when the publications are back, I print them out. I either have to go to the county and get them, or if they're on texasresearch.gov, I can print them out, and I check the names, the dates of service, make sure they put the right court on there, because judges do check that stuff too. And then I file a report with the court detailing what information the petitioner gave me, what information or what websites I used, what I did to try to contact the person. And I also put all the information in my report about the dates of service on the one or two publications. And then I file that with the court. And then I also notify the attorney of record, which would be you if you're the DFAP attorney, saying, I'm ready. What you need to be aware is most Dallas County judges are not going to order child support to be paid by the father on a publication, because they take the position, like I take the position, is that he's not probably before the court as far as personal jurisdiction. You just have in rem jurisdiction to grant maybe the divorce or the modification or whatever. So don't count on child support or medical support being put in your order. If you put it in there, I usually, as that publication allowed them, tell you that I can't agree to this order, because I won't even sign off on it as to form. And if they say, well, we'd still like to leave it in there, I let them, but then I just bring it up to the judge at the prove up. And then the judge normally does strike it or tells them to send in a new order without that in there. There's other counties that touch Dallas County that will order the child support. I still object to it as the publication attorney when they're in court or on Zoom, but that's up to the judge. The judge can do whatever the judge wants. One thing you need to be aware of is that the publication ad litem is not your general attorney. He's there just to make sure that you, as the petitioner's attorney, have followed the law as far as publication goes, that the returns were done properly. He's not there to argue this client doesn't want the divorce. This client, my publication attorney or my publication respondent should have part of the house. I know that if you look in the family code, it says that you're supposed to defend the publication person, but we interpret that to really mean that as a publication attorney, you're just there to make sure that the law is followed, okay? And you haven't talked to a publication person anyway, or I haven't talked to a publication person, so I don't know what he wants. He may want the divorce. He may want to be terminated. He may want his wife to have the house. I don't know, but my job is just to make sure that he was notified under the law to be, and that he's properly before the court. And as Don says, there always has to be a statement of evidence, and the judges look for the statement of evidence. They can be very short, or they can be detailed. But I usually do the statement of evidence and send it over to the petitioner's attorney, and then we just set it for approve up. Make sure you check with the publication at Litem to make sure he's available for the approve up. Don't schedule approve up and then notify him, hey, you got to be in court on this day or on Zoom on this day, because it's not fair to the publication attorney. And then
Jim, you're on mute.
thank you. Most of the judges a lot of the judges are letting their associate judges handle the prove ups now. They're being done usually at 8:30 in the morning. I know Judge Diaz does hers at 8:30 in the morning, and so does Judge Bedard. Judge Amadroth does hers at 3 o'clock in the afternoon for the 302nd. But one good thing is that they will also still, most of them will still let you do divorces or cases by submission. I know Judge Brown in the 301st is still big on affidavits of testimony and then she'll grant the requested relief by submission. But all the judges are very nice. They'll work with you. If you're not familiar with them, they're not there to make you look like idiots. So you should have fun dealing with a publication ad litem when you're the petitioner's attorney. That's all I have.
Jim, could you address, like, you find somebody and they call you?
Oh, okay.
What do you do?
That does happen. Maybe twice a month I'll find somebody and they'll call me. So what I do is I explain to them that they don't have to participate in the case, and if they don't participate, this is what could happen. And if they don't want that to happen, then they need to file an answer. They don't know, probably the pro se respondent doesn't know how to file an answer, so I'll draft a potential answer and send it to them that says, my name is so-and-so. I've received notice of the divorce through Mr. Cobb. I want at least 45 days notice of a final trial setting. The information below is correct, and so I'll get a good email address, phone number, and address from them, and then email it to them. They'll sign it, send it back to me, and then I'll e-file it for them. And then they're before the court, and then I'll send an order in to the court releasing me as the publication attorney. Does that answer your question, Don?
It does. I'm always concerned whether I should just give that information to the attorney on the case, or if I should do as you said. And I always kind of usually opt what you just said, but sometimes in my brain I go, Dawn, you're not staying within your boundaries.
I have found that a lot of times the respondent who I'm dealing with doesn't want the petitioner to know their good address for service. Now you do have to put an address on the answer. So I tell them to put a friend's address or relative's address that they know will notify them of any mailings that come out, and they do that. Or by the time they try to get them served, they're gone from that address. That's a problem too. So that's why I try to get them to do that pro se answer.
Yeah, I found a lady on the beach one time and I sent her stuff to a FedEx office.
Well, I found a lady one time, yeah, and she didn't have the internet, so I had to meet her at a CVS and bring her the answer, and I finally located her even, and she signed it, and then I filed it for her. So it's best if you can get a pro se answer out of them to get the case moving.
Yep. See if we have any questions.
Yes, thank you, Dawn and Jim, for a wonderful presentation. We do have one question. Do we need to file a motion and order to get an ad litem appointed by court in publication cases, or court order not necessary?
Court order is not necessary. You need a court order, but you don't need a motion. You can just email the court or the coordinator saying, hey, here's an order to appoint a publication attorney. Please have the judge sign it. Or you can e-file it, but they need to know, it could sit in the e-filing forever and they not act on it. So, but you don't need a motion. You just need the order.
Great. Thank you. I don't see any additional questions in the Q&A, but if you do have questions, please feel free to drop them in there. While we wait, I do want to provide the course code for today, and that number is 174-274-966. Again, that is 174-274-966. That will be emailed to attendees later this week. And the documents that Don and Jim mentioned throughout their presentation will also be emailed to everyone who attended. Seeing no additional questions or comments, I thank you both for presenting this afternoon. Thank you everyone who tuned in, and we hope that everyone has a good rest of their afternoon.
Thank you,
Thank you.
everyone. And our
Thank
contact
you.
our contact information is on our papers, so feel free to reach out.
Thanks, Don. Thanks, Jim. Have a good rest of your day.
Bye-bye.